Allen Company, 47 years young and a proud sponsor, wishes OOIDA all the best as you celebrate 50 years.
OOIDA, representing America's truckers since 1973, presents Landline Now with your host, Scott Thompson.
The state of Rhode Island's attempt to overturn a ruling that ended the state's truck-only toll scheme is now in the hands of the U.S. Court of Appeals. Landline Magazine's Ryan Witkowski has been following the case from the beginning. He'll get us up to speed on the specifics of the state's appeal and where things go from here. As Frank Costanza of Seinfeld might say, it's time for the airing of grievances. Truck drivers have a lot of problems with the DataQs process, and the reform process begins now. Jamie Jones and Mark Schrimmer of Landline Magazine stopped by to provide some context for the conversation now being had before doing the same about this week's House hearing on autonomous trucking. And then our celebration of OOIDA's 50th anniversary continues with a look at another association victory. This one is multiple victories, in fact, throughout several states over several years involving tax cases that gave money back to owner-operators, as OOIDA historian Sandy Sonker tells us. All that and more on this Friday. But first, the news with Ashley Blackford.
Thanks, Scott. $48 million has been awarded to increase CDL driver training opportunities and to continue improving the process for obtaining a CDL. This week, the U.S. Department of Transportation's Federal Motor Carrier Safety Administration announced that this grant funding will go to states and other entities for operating national CDL programs. The programs will help states expedite CDLs and renewals and will ensure states electronically exchange conviction and disqualification data. U.S. Transportation Secretary Pete Buttigieg said these grants will help states bring more well-trained drivers into this essential field, which will strengthen supply chains for years to come. Two truck parking bills have gained more support in the House and Senate. Recently, two senators signed on to the Truck Parking Safety Improvement Act. This Senate bill would establish a competitive grant program for projects for commercial motor vehicle parking. The Truck Parking Safety Improvement Act in the House also has received more support, with another co-sponsor signing on Thursday. Both these bills have bipartisan support. A bill has been advanced that clarifies the federal law to ensure that the tenure of an acting Secretary of Labor aligns with the Federal Vacancies Reform Act. This week, the House Committee on Education and the Workforce advanced Representative Kevin Kiley's bill, the Department of Labor Succession Act. Julie Su was nominated in February to be the U.S. Labor Secretary. However, her confirmation has never been taken to the Senate for a vote. Congressman Kiley said Su does not have the votes to be confirmed as Labor Secretary and that appointing her was a mistake. He also said it's time to move on and appoint a new secretary. The bill now heads to the House floor. If you're using a Falcon or KSK electronic logging device, you need to switch to paper logs or logging software. The Federal Motor Carrier Safety Administration announced that those two ELDs have been removed from the list of registered ELDs. FMCSA said this decision came after the providers failed to meet the minimum requirements of a regulation that requires that an ELD without a printer be designed so that the display may be reasonably viewed by an authorized safety official without the official entering the vehicle. Motor carriers have up to 60 days to replace the revoked ELDs. Beginning November 13th, those who continue to use the revoked devices will be considered to be operating without an ELD. The project to widen I-94 to 6 lanes in Kalamazoo County and rebuild the Portage Road interchange is entering its final stages. Michigan's Department of Transportation says with all 3 westbound I-94 lanes open and the opening of all 3 eastbound lanes in sight, contractors are anticipating a mid-October completion of work on this 3-year project. The total cost is about $87 million. There will be some intermittent short-duration total closures of eastbound I-94 to hang signs over the travel lanes, which will be assisted by law enforcement. There will also be some shoulder closures for sound wall completion, but MDOT says neither job is expected to have significant impacts on I-94 traffic. North Carolina's Department of Transportation will soon have a new way to mitigate wrong-way driving incidents. NCDOT has partnered with NTT Data, a global digital business and IT service, to implement the smart traffic solution. According to a press release, optical sensors will be strategically positioned across 12 key North Carolina state highways and connected to NTT's smart management platform to acquire relevant data regarding wrong-way driving events, as well as access highway conditions. The state traffic engineer Brian Mayhew said wrong-way driving is a concerning challenge despite advances in transportation infrastructure, design, and technology. He added that data and insights gained from this project will be used to develop data-driven strategies for continuing NCDOT's dedication to providing a safe, reliable, and efficient transportation network. U.S. Department of Transportation crews in Maine are preparing for Hurricane Lee. Paul Merrill is the Director of Communications for the Maine Department of Transportation. He told a local news channel that Maine DOT will be monitoring weather reports over the weekend, and crews will be working 24/7. Hurricane Lee is expected to bring strong winds to New England. Merrill expects the storm to have statewide implications. The Department of Transportation has announced a public meeting on human trafficking. The meeting is scheduled for October 3rd at the U.S. DOT office in Washington. This meeting comes a few months after the Federal Motor Carrier Safety Administration announced its new human trafficking awareness campaign called Your Roads, Their Freedom. The goal is to give commercial motor vehicle drivers the information to identify and report incidents of human trafficking. California's Highway Patrol is putting out a warning to truck drivers. The commercial vehicle section of CHP posted recently that items on the dash or hanging in the front window of a truck are illegal. Tinted windows in the front and sides of a CMV are also illegal. The post stated that a clear view of the roadway will help keep everyone safe on California highways. And finally, as Truck Driver Appreciation Week wraps up, C.H. Robinson is also wrapping up its Miles of Gratitude tour. In an effort to show truck drivers how much it cares, C.H. Robinson toured across the country, stopping at truck stops and handing out food, gift cards, and a chance to win a cash advance payment. Bruce Johnson is Director of Capacity Development at C.H. Robinson. He said it's been wonderful getting to stop and chat with drivers this week.
It's been an unbelievable week. As at first they see us and they're wondering, I think, what the heck are we doing there? Are we trying to sell them something? But once we tell them, hey, we just want to appreciate you this week, and here, come and take a few free items from us, they're all incredibly thankful, and I think they're just glad to have somebody out there at the stops telling them thank you for what they do. We don't do that enough throughout the year, so at least this 1 week, we're able to really make sure that they understand that.
This morning, the tour came through Kansas City with a stop at the Owner-Operator Independent Drivers Association.
So we wanted to stop here at OOIDA and just thank all the employees of OOIDA. We have a great relationship with the organization. We want to make sure that continues on and that they know we appreciate them as well, along with the drivers and all the drivers that they represent.
National Truck Driver Appreciation Week may officially end tomorrow, but both C.H. Robinson and OOIDA appreciate the hard work drivers put in every day of the year. That's Landline Now News for today. I'm Ashley Blackford.
Thanks, Ashley. We're not far away from our annual Truckers for Troops telethon, but you don't have to wait to make a difference. You can make a donation all year round through the OOIDA website. The Truckers for Troops program sends care packages to U.S. troops overseas and supports efforts here at home through the Veterans Community Project. Just go to the main menu at the upper left corner of OOIDA.com, then under Membership, click on Truckers for Troops. Coming up next, Ryan Witkowski of Landline Magazine joins the show to walk us through what's going on with the court case surrounding Rhode Island's truck-only tolling program. So stick around, we've got lots more show to come. We'll see you on the other side of this break, right here on Landline Now.
Thanks for listening. Be sure to like and subscribe. If you want more content, go to landline.media to get updated news, information, and archived editions of our show. Once again, that's landline.media.
Firestone tires are for more of everything. More miles for every tire dollar, and more confidence in your fleet. At Firestone, we help fleets save with dependable value. Find your local Firestone dealer today at firestonetire.com/dealer.
Ready to make more money? use a better load board. For a limited time, get 50% off TruckStop Load Board Pro. Just go to truckstop.com/go and enter promo code READY2023 when you purchase Load Board Pro.
Rhode Island's attempt to overturn a federal court's decision that ended the state's truck-only tolls program is now in the hands of the U.S. Court of Appeals. In June of 2018, the state began collecting tolls on 12 bridges for Class 8 and higher commercial vehicles. The intention of the tolling scheme was to fund the state's roadworks program, which makes improvements to Rhode Island's aging bridges and roads. According to the state, commercial vehicles account for around 70% of the damage to Rhode Island's bridges. In fact, the state says it's facing an infrastructure crisis and claims to have the single worst record for structural deficiencies nationwide. According to Roadworks, 23% of the state's bridges, around 200 total, have been deemed structurally deficient and many more are functionally obsolete. Despite pushback from those within the industry, both local and out of state, Rhode Island pushed forward with their tolling scheme. They contend that truck tolling was used as an alternative strategy for funding infrastructure improvements after federal funds, state bonds, and fuel taxes failed to generate sufficient revenue for the needed repairs. They continued collecting tolls until a lawsuit brought forth by the American Trucking Association brought that to a halt. The suit successfully argued that Rhode Island's plan violated the Commerce Clause of the United States Constitution, which forbids states from imposing charges with the intent to discriminate in favor of domestic and against out-of-state or interstate entities. In September of 2022, Judge William E. Smith of the U.S. District Court in Rhode Island ruled that a permanent injunction be granted and ordered the state to stop collecting the tolls on large commercial trucks within 48 hours. In his decision, Judge Smith said, quote, "Rhode Island has a legitimate, even compelling interest in the maintenance of its ailing bridges, but there is no reason that interest cannot be served by a tolling system that does not offend the Commerce Clause. Indeed, many states have implemented tolling systems that fairly apportion their costs across various users and do not discriminate against interstate commerce." End quote. The 12 truck toll locations across Rhode Island had generated approximately $100 million in revenue for the state prior to being shut down. In October of 2022, Rhode Island Governor Dan McKee announced his administration would be seeking an appeal of the federal judge's ruling. At that time, State Attorney General Peter Neronis said he felt the state had a strong case, and in February, the state filed their initial brief in the case, saying the application of the Commerce Clause by the federal judge was misguided and problematic. Ahead of the case being heard by the U.S. Court of Appeals, industry stakeholders expressed an overwhelming support for the court to uphold the district court's ruling that put an end to the truck-only tolls. In May, a brief was filed by the U.S. Chamber of Commerce in which the group argued the previous court's ruling was just, going as far to call the state's roadworks program a clear violation of the Commerce Clause. The group also asserts the roadworks program is discriminatory in purpose, pointing to changes made to the original draft of the program's proposal, most notably to which vehicles are being tolled. The Chamber wasn't alone in their belief that Rhode Island's tolling plan disproportionately impacted out-of-state users. A collaborative amicus brief was filed in June by the American Highway Users Alliance, Intermodal Association of North America, National Association of Truck Stop Operators, Truckload Carriers Association, Truck Renting and Leasing Association, along with trucking associations from every state except Delaware and Kansas. In the brief, the groups argue that Roadworks' classification system exempts around 97% of the total vehicle traffic on the tolled bridges, including passenger vehicles, buses, and Class 5 through 7 trucks. While many in the industry were calling foul on Rhode Island, the state wasn't without support. In March, the International Bridge, Tunnel, and Turnpike Association filed an amicus brief with the U.S. Court of Appeals in support of the Rhode Island Turnpike and Bridge Authority and their efforts to reverse the earlier decision. The brief filed by the group argues several points about the tolling industry which they felt the court should consider, including, first, tolling is only one source of revenues to support programs like Roadworks. Second, substantively, it is key that interstate commerce behavior was not materially affected by Roadworks. And finally, from a procedure standpoint, Roadworks took all reasonable measures to make a fair approximation of use. Additionally, the group says that from a global perspective, it is not unusual to toll only large trucks, citing European countries like Germany, Denmark, Luxembourg, Belgium, Bulgaria, and Sweden, who have all enacted truck-only tolls. In its brief, the group argued the state's tolls had no impact on out-of-state traffic. Before the tolls were enacted in 2018, opponents of the idea argued that truckers would alter their routes to avoid paying the tolls in Rhode Island. However, the group points to figures from the Rhode Island Department of Transportation, which showed that after 6 months of charging semis, the truck toll volume was running ahead of the state's expectations. They contend these numbers showed that truckers plainly did not take alternate routes to any material degree, and that the tolls had no effect on interstate commerce. After months of back and forth, the state would get its day in court. On September 12th, attorneys for both sides presented oral arguments to a panel of judges at the U.S. Court of Appeals for the First Circuit in Boston. Representing Rhode Island was attorney Ian Gershengorn, who says the district court's ruling undermined the state legislature.
Rhode Island's legislature imposed a facially neutral toll on the biggest trucks that caused the most damage to Rhode Island's transportation infrastructure. In striking down the legislation, the district court misapplied the Commerce Clause, and it took for itself decisions that belong to the state's elected representatives.
A key component to the state's case centered around the tolls being fairly approximated based on the federal classification for commercial vehicles. However, according to court documents, the original proposal called for tolls on large trucks Class 6 or higher. However, following feedback from the local trucking industry, who operate the vast majority of Class 6 and Class 7 trucks that would be using the tolled bridges in the proposal, a second version of the proposal was drawn up. The new version featured two major differences. Class 6 and 7 vehicles would be exempt from tolling, and a limit was added for repeat per-day visits to a single toll gantry. Circuit Court Judge Kermit Lipez pressed Gershengorn about this fact.
The district court spent a lot of time with a kind of mathematical analysis showing that given the frequent use of local truckers of these bridges, given the cap that they could then take advantage of, there was a significant difference between sort of the cost per mile of these tolls on the interstate truckers and the local truckers. The court demonstrated that and said that that mathematical demonstration, if you will, reveals the discriminatory effect of what's going on here. Are you saying that that was just a large irrelevancy, that simply should not factor in to the dormant Commerce Clause analysis?
Gershengorn replied that trying to maximize in-state business to help local residents is something state legislatures do every day, stating that taking account of local concerns is the core of what legislatures do. Furthermore, he added that no evidence supports the claim that the state sought to benefit in-state truckers at the expense of out-of-state carriers. Additionally, Gershengorn argued that the exclusion of Class 6 and 7 trucks was based on weight rather than pressure from local stakeholders, because Class 8 and higher were responsible for the lion's share of damage to the state infrastructure. As for Judge Lipez, he didn't see it that way.
We've been talking about the relevance of evidence of discriminatory purpose, discriminatory intent. There is a lot of evidence in this record that the distinction between Class 8 and Class 7 really had very little to do with the difference in physical impact on the structure. There's a lot of evidence that it was designed to placate local business interests who felt they would be severely hurt if this toll applied to the class of trucks that they use. So in making a judgment about how reasonable the judgment was between Class 7 and Class 8, doesn't that evidence sort of affect the credibility of the legislative determination? Yeah, there's evidence in the record that there's a different physical impact, but the real reason for it was protecting local interests. Isn't that important for us to consider?
Throughout the proceedings, Gershengorn maintained that Rhode Island took measures to ensure a fair approximation of the tolls across all users. As evidence of this, he pointed to the state's daily cap. Lipez countered by likening the cap to a flat tax charged to all truckers, something Gershengorn says is simply not correct.
The caps do not function like a flat tax. Whether you structure something as an upfront fee and then discounted tolls the rest of the way as enduring. Or you structure it as you pay once and you ride as many times as you like, as like a commuter card. Or you structure it as you pay the actual toll up to amount and then there's a cap. Those are all ways to give a frequency-based discount. The Constitution cannot be that the Constitution prefers one of those over another. Second, unlike a flat tax, Your Honor, there is no tax on entry into the state. If you come into the state and don't drive through a bridge, you pay nothing. If you drive in the bridge and cross through one toll, you pay one toll. If you cross through this into the state and pay two tolls, you pay two tolls. And it's the same for in-state and out-of-state. The fact that there's a cap on the back end that resets every day, you come in the next day, you pay those tolls again, is crystal clear evidence that it is not a flat tax. Just because you reach a cap on a variable tax does not convert the entire tax scheme into a flat tax. I think that's critically important.
It does function like a flat tax. Once you hit that cap, the cost per mile of usage, there'll be a huge difference between the local truckers who go back and forth over these bridges. And once they've hit the cap, they don't have to pay any more. And so they're getting a much bigger break from that cap than the trucker who goes through the state, pays it once, and then goes on.
The state has been persistent in its argument that the truck-only toll does not disproportionately impact out-of-state drivers because the tolls are usage-based rather than being a tax at the border. However, Circuit Court Judge Julie Reichelman pointed to evidence showing 80% of the tolls were collected from out-of-state truckers. Despite this, Gershengorn maintained that the state's truck-only tolling plan was not created with discriminatory intent and that the plaintiffs had not provided sufficient evidence to prove a discriminatory effect. For Judge Reichelman, it was an explanation that just didn't add up.
I understand, of course, your argument that if you're Class 8 and above, you get told the same amount whether you're in state or out of state. But it seems that there was a trial here. And what the district court concluded was that Class 8 and above was just a proxy for discrimination. And what the state has done, if you take a step back, is it's chosen a category for tolling for this program, a category that's 80% out-of-staters. So I guess my question for you is, if Rhode Island had chosen a category that was 99% out-of-staters to toll, are you saying that still wouldn't be enough to show discriminatory effect to get strict scrutiny?
At some point, it becomes sufficient, and this court has held that in family winemakers, right? That's the family winemakers case. Whenever Massachusetts set up a system, every single one of the winemakers made it. The court said, of course, that's not facial, but it's basically
So why is 80%? If 100% is enough, why is 80% not enough?
Attorney Charles Rothfeld is representing the appellees in the case. He said the state's arguments are setting a dangerous precedent when it comes to discriminating against out-of-state commerce.
I think it's sort of helpful to take a step back and think about the consequences of the argument that are being made by Rhode Island. The state takes the position that an intent to discriminate is irrelevant. Mr. Gershengorn took the position that kind of aggregate discriminatory effect is irrelevant. If that's true, then state officials can decide we want to discriminate against businesses that are based out of state and can get disproportionate benefits for in-state competitors based in our state. And we can announce, they can announce that publicly, that this is our intent. They can instruct a state agency to come up with a facially neutral regime that inevitably will have the effect of imposing disproportionate burdens on out-of-staters benefiting in-state competitors.
The parties will now wait for the court to make its decision. There is no timetable for the ruling, but it will likely be months before a ruling is made. In some instances, it could take as long as 2 years for the court to render a decision. Both Gershengorn and Rothfeld did not respond to Landline's request for comment. For more information about Rhode Island's attempt to overturn the truck-only tolling verdict, head to landline.media. For Landline Now, I'm Ryan Witkowski.
Forget misaccuracy, weigh your truck on a CAT scale.
When you weigh on a CAT scale, you get a no excuses guarantee. You can now save time weighing by using your smartphone. Find out more at weightmytruck.com.
Since you started, what you've loved about trucking is the freedom. Heading out on your favorite route, a good driving song, and thinking about truck insurance. Well, maybe not that last one, That's why we're here. At OOIDA, we have a full range of truck insurance products, expert advice, and great customer service, helping you get the right coverage for your operation. Go to OOIDA.com because your job is to drive. Our job is to help with everything else.
Welcome back. It's Friday, which means it's time to wrap our heads around some of the biggest stories of the week in trucking. And if it's Friday, and if we're doing that, that usually means a visit from Jamie Jones and Mark Schrimmer of Landline Magazine. And sure enough, here they are. Jamie, Mark, good to see you.
Without further ado.
Yeah, exactly, yes. I want to start by spending some time on an issue we spoke with Jay Grimes of OOIDA's Washington, D.C. office earlier in the week about, that being FMCSA taking a long, hard look at the DataQs process, which, as we have pointed out numerous times, and our listeners know, can be a very frustrating process. Jamie, we were talking yesterday about this, and you've since put together an opinion piece on this for Landline.media. You've had some experience covering this over the years, and that has shaped how you view this comment period that's now open. I want to give you the floor and let you do what you will with it.
History lesson.
Yes.
Well, in the year of our Lord, 2006.
We're going biblical. All right. Very good.
Yeah. So seriously, in November of 2006, I was at a press event in Washington, D.C., where then Administrator John Hill of the Federal Motor Carrier Safety Administration announced this new data-driven system that they were going to unveil that was going to reduce truck-involved crashes. And at that point, it was CSA 2010, and it was going to launch in 2010. And that first one, everybody's like, okay, the data in theory was going to identify carriers with high-risk tendencies that would be more likely to be involved in a crash. And, I think to criticize the overarching concept would be probably dumb because it makes sense on the, from a 30,000 foot level. But we kind of left that first event because they didn't have detail. And we all know that any big project like this, the devil's going to be in, devil's in the details. So, fast forward a few more months, and there was another event in Dallas where they had another, and this was industry stakeholders. So I was just tagging along as Landline with some OOIDA folks who were there representing. And they had breakout sessions where they would go into different detail on the program. And I went into one, and the question was asked, what happens if you're going to record all inspection data into this CSA 2010, what happens if there is a violation mistakenly noted on an inspection report? How's that going to be fixed?
Important question.
Yeah, and they were like, no, if it's on the inspection report, we're just going to include it. And there was an attorney in the room, and he said, well, okay, let's flesh this out a little bit more. What happens if there's a violation and a corresponding ticket is issued, and so it gets, its due process with the courts, and it's thrown out or reduced to a different charge that's not corresponding to the violation? The FMCSA rep stood there, straight-faced, and said, I don't care what kind of backroom deal they made with the judge. They did it, so they're getting stuck with it. That's not a direct quote because there's been a lot of sleeps and eats between, from 2006.
But that's the gist of it.
Yeah. That's the gist of it. It doesn't matter. And so that was the mentality that this program was initially planned to be. And so there was a ton of pushback following that.
Rightfully so.
Yeah, and not just from OOIDA, who was extremely vocal in it, but you had, lawyers involved with other organizations. They're like, this does not work. You are setting up roadside inspectors as judge, jury, and executioner. So they came up with their first DataQ challenge, data quality challenge. And the way that worked in most states is it would go back to the issuing officer if you appealed it. They're not going to say, oh, you got me. I was wrong.
Oops.
Oh, I'm sorry, buddy. I didn't mean to do that to you.
Yeah.
No, that doesn't work.
No.
And, every refinement, and I'm using air quotes. I know nobody can see them, but every refinement they've done to it to this date has not really improved the process tremendously. And it was a problem from the start. Everybody knew it was a problem from the start. And here we are 17 years in, and they're just now finally taking a hard look at the biggest problem with the program.
In the year of our Lord, 2023. Yeah, and that is the frustrating history, I guess, of this leading us up to now. And Mark, we now have FMCSA looking at this issue, asking for feedback, asking for people to weigh in about the very frustrating process that this can be. So we're taking a step here.
Yeah. So they're proposing an idea of an appeals process to where it's not the same person that gave the original violation,
or even the same agency.
Yeah, exactly. And so that is good. But based off of the history lesson that Jamie just gave. It's hard to have complete confidence in how this is going to go. So we're just going to, like you said, devil's in the details. Once we, I think it's going to be a 60-day comment period. Once those get in and we're able to, see what the feedback is and then get a more detailed proposal, then we'll see where this goes. But kudos to OOIDA and the truck drivers over the years that have kept on pushing this issue to get it to this point, and hopefully we make some progress.
Well, and, I never channel Pollyanna well at all. That's just not my personality. That's not my personality.
Yeah.
But
shocker.
The other thing that we have to keep in mind when we're talking about this, every crash used to be reported to CSA, regardless if you were at fault or not. OOIDA had a member years ago. There was like the swamps or whatever in Florida were on fire, and then there was fog. I mean, it was a complete whiteout situation. The member got stopped in their truck safely, but they're on the road, got hit by 7 different passenger vehicles, and that resulted in 7 different crashes on that member's CSA. And so now we have the crash preventability review, where certain crashes, you can submit those, if they were non-preventable, that those are no longer counted against you. So they did make and are continuing to expand that program. So they have wised up on that angle. So maybe this is a lesson learned that we're seeing, and now we're looking at DataQs going, hey, maybe they were right. We are doing this wrong.
Well, and I want to point out and emphasize, as you mentioned, the comment period is now open for 60 days through, middle of November. This is the time for the airing of grievances, as Frank Costanza of Seinfeld might say, and you reference this in your story, Jamie. But now really is the time, if you've had experiences like this, you got to point them out.
Yes.
Because the more stories like this that regulators read, they're going to realize this process is really flawed. We need to do something.
Right. So submit those documents, because you're able to submit documents with your comments and things like that. So have your alibi copy right there with you. Get that uploaded, scanned in, whatever you have to do. Make them look at these again, because this is the best opportunity we've had in a long time for meaningful reform. But if we don't have enough ammo come in during this comment period, we could see a swing and a miss on the end result.
Let's shift gears here to this autonomous trucking hearing that happened in the House this week. We covered this quite a bit throughout the week here on the program, and I know you did as well with Landline Magazine. Lots of concerns leading up to this hearing, warranted, I might add, about the lack of someone representing small business truckers in particular, or really truck drivers in particular here, about a technology that could very well take away their jobs here in the future. Mark, you covered this event. I just want to ask you what stood out to you as you kind of listened to everybody speak there and the direction of where things went.
Well, I'll say 2 things. First was I do think that a lot of the lawmakers heard from OOIDA and the criticism.
How could they not?
Truck Driver Appreciation Week.
To do it during that time, I know it's been repeated a ton of times, but I don't think you can repeat it enough to hold a hearing on something that could potentially replace truck drivers during National Truck Driver Appreciation Week and not have any of those drivers even on there to testify is just absolutely ridiculous. Luckily, several of the lawmakers did note that and also used a little bit of the driver perspective, showed a lot of skepticism toward the AI proponent witnesses that was mainly on the panel. The other part of it that I would say that I think really stood out to me is that ATA, as we know for years, have built up this whole thing that there's a driver shortage, and they have convinced lawmakers that there is one. They convinced for a long time. They convinced mainstream media that there was one. We've seen articles around all the time, and there were a lot of questions during this hearing about, hey, is this going to displace jobs for truck drivers? And everything from ATA, Chris Spear, who was representing them on the witness panel, was building around, no, there's a driver shortage. So, we got to replace, by 2035 or whatever year he said, we're going to need 1.2 million drivers. So that's all this is going to do. Nobody's going to lose their job over this. And, meanwhile, in recent weeks, I'll point to another story that we did. John Bendel, one of our contributors, that had FreightWaves put out an article similar to what Landline has done for years, saying that there isn't a driver shortage. And ATA kind of lost it and wrote a blog back getting into a feud.
There was no kind of to that. That doesn't need a qualifier.
And we've just been sitting around eating our popcorn, watching this. We've been enjoying it. But so they're fighting, and I'm saying, well, why are they getting so upset? Because we've said this for a while. I mean, NBC just recently had a report. I mean, a lot of things are now but they're starting to get really upset about this. And part of it, I think, is their whole argument for driverless vehicles of why they could tout them hangs on this idea that there's a driver shortage. And you saw that throughout the entire hearing. I'll give a quick shout out to Representative Jeffrey Drew out of New Jersey. Mm-hmm. He said, I've had a lot of people look me in the eye and say this isn't going to happen over the years, and then it does. And he kind of really called him out for that. But yeah, those were the things that kind of stood out to me.
I think the one funny thing that we just found out this morning from Georgia O'Connor from our D.C. office is ATA literally held a driver appreciation event. Like, what do you say, 300 yards?
300 yards, yeah.
300 yards away, where they had their truck out there handing out goodie bags to drivers and all this stuff. And then the same people walked straight to that hearing to advocate for driverless trucks. And it's like, I mean, optics, people, come on. I mean, if nothing else, you clearly do not value the people behind the wheel. And that's a problem.
Yeah, and I will say, just to kind of piggyback on what you said, Mark, it was refreshing to see a number of lawmakers speak up, and healthy skepticism, I guess, is one way to put it, but they did mention specifically that this is a major concern. Are we going to be pushing out this technology that is pushing out hardworking truck drivers that are on the road now, that are going to be on the road in the future? So it is refreshing to see that they are going to, I think, hopefully, maybe, approach this issue with a level of scrutiny that really needs to be had.
And scrutiny on the safety of the tech as well.
Exactly. 100%. Yeah. And Kathy Chase, Advocates Highway Safety, was on that panel. Yeah. And, real quick, San Francisco example, she brought up that driverless vehicles that have been tested have been blocking firefighters and blocking police officers.
There's wrecks all the time. Yeah, it's something we're going to be talking about for a long time. And I'm sure we'll talk about it again. Mark, Jamie, pleasure as always.
Oh, you're welcome, Scott.
Thanks.
You can check out Jamie's op-ed on the DataQs scrutiny, Mark's work on the autonomous truck hearing, and anything else trucking related on the Landline website. That's landline.media. We're back in a moment. Stick around. Landline Now is back right after this.
Control your toll costs and eliminate tolling headaches with Prepass Tolls. Prepass Tolls means toll volume discounts. Just one invoice for all tolls and fewer violations. Call 877-878-5970 or go to prepass.com.
Attention all truckers, Dean Michael, the tax doctor here. I want to talk to you about those dreaded tax problems. I know you want to keep on trucking and not even think about them, but let's face it, they're not going away all on their own. You need professional help. I've been helping truckers put their tax problems in the rearview mirror for years. I can help you too. Call me now for a free consultation at 888-557-4020 or go to mytaxhelpmd.com. It's like I always say, keep your eyes on the road, I'll keep mine on the IRS. 888-557-4020.
It's tested and proven. Burn 2.1% less fuel when you balance all wheel ends with Centromatic. Call 800-523-8473 to get the OOIDA discount. Landline Now, welcome back. It's time for another of our 50 on 50. 50 significant events from OOIDA's history in celebration of the association's 50th anniversary.
I'm joined now by OOIDA historian Sandy Sonkern. We're talking about a specific set of court cases involving state governments in which OOIDA intervened or participated in.
Hi.
Sandy, welcome.
Glad to be here.
Let's start with intervened or participated. What does that mean in layman's terms?
Well, if somebody else files a case and you have an interest in that case, or you actually have a reason to be involved in it, you can intervene and say, hey, this is not all about you. We are a subclass. You got a big motor carrier. That motor carrier may have owner-operators leased who have an interest in this case, who are also seeking justice. But they don't have a whole lot of money to go in by themselves. So as members of OOIDA, we would go in and intervene with our lawyers. Now, if we participated, we would ask to be established like as a subclass.
Okay. So it's basically getting involved so that the owner-operators would get the money that they were due instead of just the motor carriers.
Absolutely.
So let's talk about some of these cases, and there's a long list here. I'm going to go over some of these, but we had intervening in a New Jersey case in 1984. We had New Hampshire in 1985, a suit over Indiana's fee, participating in a suit over a Vermont decal fee, Maryland, Georgia, Florida, Maine, Arkansas, Mississippi, Massachusetts, Kentucky. This is a long list of cases that the association got involved in. And it was all, correct me if I'm wrong, but basically to make sure that the owner-operators were the ones that actually got the money that they had paid in the first place.
The ones that were leased to motor carriers, they had to be fairly reimbursed, and they had to be to get those refunds back directly. And that was an important thing why we had to actually step up. We couldn't depend on them, to say, okay, well, we'll go through our rolls, and if we had owner-operators that paid this, we'll pay them back. No.
Well, talk a little bit about the common theme of these cases. I mean, these were all kinds of different fees, but what was it about these fees that brought this to court in the first place?
Well, we felt that they were discriminating against the little guy. ATA felt like they were discriminating against the motor carrier. Of course, you have to think, too, when we won the cases, big motor carriers didn't squawk too much because guess what? They got their money back as well. If we won a case against a state and refunds were ordered, motor carriers got refunds. Owner-operators got them too. But everybody got paid back.
Well, as I recall, and again, correct me if I'm wrong, but a lot of it was that they were charging the same fee to a trucker that did 1 mile in a state as much as they would charge a trucker that did all their miles in that state. It was the same fee, and it should have been proportional. I mean, am I on base there?
You are. And that's kind of the message that OOIDA was sending out with like all the states that you mentioned that we intervened, is that if states are thinking about tacking on flat fees to their state truck taxes, and if they think that it won't be noticed, and if they think big motor carrier won this, but the owner-operator, is pretty much out of it, they need to understand that it's not a good idea to keep tacking these on. We will notice, and we'll take them to court in a heartbeat. We'll intervene. We will participate as subclass representatives. It was quite a project. It was probably so astronomical in figuring out the logics of it that a lot of the motor carriers that were in, they didn't figure that we would do it. They figured the money would really all go back to them.
And that was part of the reason, despite the fact this was such a drain on resources. And we have to remember that OOIDA was not the same size organization back then that it is today. It was really a monumental effort for an association of that size. But that's why they went ahead and spent that money and went through that effort, right?
Truly a drain on resources. But our leadership, our executives always said, well, that's what we're here for, and that's what the resources are supposed to be doing, is creating like that level playing field for the people we represent. So the foundation of that level playing field is case law. And that is what OOIDA has been doing, building case law with all of these actions, all the intervening, all of the participating in everything. We're just essentially making new case law as we go and making it stronger. I mean, that precedent it has got to be there. And so far, we've been pretty darn successful in establishing those that were favorable to the little guys and gals.
Well, and it continues. I mean, we had a case not just a few years ago with New York doing something very similar again.
Oh, yeah, I love that.
So even today, we still have states that occasionally try this. But obviously, these cases were also about sending a message. And what was the message that OOIDA was trying to send to these various states through these cases?
Don't try it. You've got states that are particularly the retaliatory taxes. I mean, they're imposing taxes against truckers from another state, and that state would be imposing a tax against truckers with like the retaliating against them. It was ridiculous. So the message that we're sending is that those past practices are going to be a target. We didn't stop then, and as evidenced in New York, we're still not stopping. We want those practices to cease.
I'm sure there are folks out there that think, well, somebody else filed this suit. You guys were just playing Me Too at this. But it really isn't that, is it? It is important to intervene in these cases.
Well, it really is. In the grand scheme of things, is that the drivers are treated like hardworking, honorable, workers that they are. It's to be able to successfully challenge a carrier on behalf of truckers. That's quite a deal. But I have to admire that the drivers themselves were so supportive of these actions. And maybe that's the message, is that we won't put up with it. Drivers are saying, we don't want to put up with this. We're getting screwed out of taxes, and we're not going to put up with it. I've talked to a lot of truckers that's why they joined the association in the first place, is that I don't have enough money to hire a lawyer, but I'm getting messed around. I'm tired of it.
This is a way to join together.
It's the message, Together we can get a lot done.
Okay, well, Sandy, we're out of time, but thank you very much for all the information.
Well, thank you, Mark.
I've been talking with OOIDA historian Sandy Saunter.
That was another of our 50 on 50. 50 significant events from OOIDA's history in celebration of the association's 50th anniversary. We'll bring you a new entry every week from now until the actual anniversary celebration.
That's our show for today. We'll be back tomorrow with more news and information. I'm Mark Rettig, and this is Landline Now.
Thanks for listening. Be sure to like and subscribe. If you want more content, go to landline.media to get updated news, information, and archived editions of our show. Once again, that's landline.media.
I'm a dad,
a son,
a husband,
wife,
I'm a writer,
photographer.
I farm.
I'm a veteran.
I love old cars, fishing,
my kids,
chrome,
and I am
a professional truck driver.
And together we are OOIDA.
OOIDA was founded by truckers to stand up and speak on behalf of truckers. We've done that by combining the individual voices of our members into a single, powerful voice. Protecting your interests, defending your rights.
Join us!
Make your voice heard. Join OOIDA, the Owner-Operator Independent Drivers Association. Call 1-800-444-5791 or visit OOIDA.com.